I would really like to welcome everybody. They're coming from all around the globe. I know I talked to a lot of people about this idea of digital premises liability. My background is an insurance underwriter, so we're the ones that put the policies together, the forms, the terms, the conditions that really are supposed to protect you. And the insurance industry built a lot of policies that you're currently buying were actually architected back in the last century, and they've kind of moved forward through time. And our industry has had to move some of our coverages to meet the unbelievable stresses that have manifested here in the 21st century. And that's specifically digital premises. We are seeing a proliferation of informational technology infiltrations and exfiltrations of data at every facet of business. We are seeing operational technologies being compromised that are affecting our critical infrastructures all around the globe. So when we started to look at these things from the optics of an insurance program, we already have mitigation in place. We are masters of loss control. We have entire buildings dedicated to it at many, many insurance facilities all around the world. We insure every contract, every covenant through contractual liabilities. We cover bodily injury. We cover personal injury. We cover property damage. Although those are tactile things that people have become intimate with, and one of the greatest ways of looking at it is a digital premises, because pretty much everybody has one, is a car and or a home. So the digital essence of a car is being transited through CAN bus, through IP addresses, through sensors, etc. And the equity of that data and the equity of the car actually has value. The vehicle itself has gone from a mode of transportation to a data platform, which anything that is connected, as everybody knows, can be compromised. The digital equity of the vehicle is what's being transited in and out of the vehicle to third parties. Very important concept is third parties. That information that's being transited is being transited via the installation of CAN buses, modems, other forms of information that are being gathered by the OEMs and put out to God knows where. That information is your information. That digital premises of you just driving your car is telling you where you are, who you are, believe it or not, who's in your car. There are cameras in the vehicles. Your privacy is being put at risk, and the digital premises liabilities that are coming into play are quite vast. When you're taking the vehicles on the road, you're transiting the tire wear, you're transiting the engine wear, the use of the fuel, right down to the little thing in the seat next to you where the car turns on every time you go to fasten your seatbelt. That means they know you're more than one person in the car, and that data can be extrapolated into so many facets of things of who you are and who you become. Obviously, that asset of yours, it's titled to you. That data is being taken out of your vehicle and sold to third parties. The question is, what happens if things can come back into the vehicle? You are seeing the hacking of the vehicles happening all the time now. Their scale of the potentiality of systemic risk then comes into play. Digital premises don't just reside with automobiles. They reside with you, your business enterprise. We in particularly have been looking at the supply chain of lawyers, professionals like myself, accountants, and looking at their digital premises. If I go into a law office or a accounting office or an insurance office, not picking on any one profession here, and I go in and I physically slip and fall because there's water on the physical floor and I injure myself, that is a premises liability. I have a physical injury that has happened to my hip, my arm, whatever. Now, if you go upon a digital premises, the website of, Scott and Scott law firm.com, and you transit business on that digital premises and it causes bodily harm and or physical damage, contractual liabilities, fiduciary liabilities. In the case of lawyers, you have the potentiality, and it's already happening, losing attorney-client privilege relationships, which means that your qualified immunity is at risk. These cases are manifesting as we speak. There was a case just recently, the Zakin case, where a law firm in California was breached, and the issue was that they were dealing with sexual harassment cases, and all of that information was supposed to be kept private. It was lost due to the cyber hygiene of the law firm, and obviously the lawsuits ensued for the bodily injury, the contractual liabilities, the fiduciary liabilities, and the loss of attorney-client privilege. The crux of this problem was our industry was putting a policy together for all of these professionals, whether they be lawyers, accountants, engineers, insurance brokers. Where does the cyber liability begin or end, and the professional liability begin or end? Well, we went to great lengths to talk to our friends in London about this very issue, and it was quite a revelation. The issue was, we have digital premises we have not even contemplated. We have digital premises we are covering. We have digital premises liabilities that are going around unfunded. Our contracts are pretty well defined, especially when it comes to the general liabilities side. We cover the bodily injury, the property damage, and the contractual liability. But now when you get to a digital premises, you have first and third party. Let's talk about first party. First party would be those people who work for you. Here in the United States, we have this thing called workers' compensation. It covers medical, indemnity, and employer's liability. I'm going to use a law firm because it's pretty easy and everybody has one, so it's going to be easy to talk about. When you have non-partners working with partners, we're going to categorize them side by side. Non-partners don't have equity in the digital premises. The ones who have the name or the shingle on the door are the ones who own that digital premises. They also get the K1. They get the benefits of being, equity owner in a law firm. But with equities come liabilities. The carriers themselves, the insurance companies, interact with lawyers all the time. There was a bit of epiphany when we found that these liabilities were extending back to the carriers, insurance carriers, who actually have to interact with these law firms who have poor cyber hygiene. It was at that point we started to really look hard at DPL, we call it, and to apply the current common law approach of premises liability to digital premises liability was linear. In other words, we're not applying what we already know to in the 20th century to here in the 21st century, but we're also not mapping the risk. The mapping of the risk is what we became particularly good at. We looked at the data, the longevity of the data, the attitude towards data. So when we started looking at what could happen on a first-party risk inside a professional firm, non-partners versus partners, to our shock, it actually became a workers' compensation issue. And you ask, how did that happen? Well, if someone who's handling an intellectual property case and the intellectual property of their client is lost due to the actions or the inactions or the or lack of cyber maturity on the digital premises of said entity, that is a massive financial loss a failure of attorney-client privilege for that non-partner. Well, what does that cause? That causes agita, heartburn, stress, which is a covered situation under medical. All they have to do is go see Dr. Feelgood, get the prescription for first aid, better known as Prozac, and at that point, they can walk into the OSHA 300 log, fill it out, and file the workers' compensation claim. That will allow a insurance company to go back to the common law book and start using the rights of recovery as subrogation. Here's the irony. Here I'm dealing with coverages that people here on this feed are talking about cyber and probably immediately thinking cyber insurance. It's not just cyber insurance. It's the ubiquity of the problem of data infiltration, exfiltration, whether it be IT, informational technology, or OT, operational technology. But when you exfiltrate someone else's data, that's a third-party risk. The exfiltration of someone else's data and the eventual loss as a fiduciary, as an attorney-client privilege, is pretty severe and warrants legal actions against professionals. And by the way, it's not just lawyers, insurance brokers, accountants, we all have this client information. We ask the questions, but we store the answers, but are we storing them well? Are we managing that risk? So in the digital premises of just the first party risk, in this case, the non-partners, the associates, all of a sudden, we are starting to actually look at all this stuff through our friends at BreachAware. Our friend Andy Alston's probably on this call. We started mapping this over a timeline. We mapped it for insurance. We mapped it for legal. We mapped it for accountants. And the amount of breach activity that we are able to see over time was a bit staggering. In other words, the law of large numbers was starting to apply. These capabilities actually exist right now and speak to your cyber hygiene. Your cyber hygiene has to be managed on a going forward basis. We are trying to get people aware that there are other digital versions of you, digital versions of your business enterprise, and we will be able to insure them, but it will take a bilateral effort to get yourself to cyber maturity. We have been blessed dealing with some really progressive law firms, and they are going through an education on this. And some of the conversations that have ensued from some of these people have really been quite productive. It's a wait a minute situation. That can really happen if you're in the room with us, as we were in Boston with some of our friends who are on this feed right now. The epiphany that's happening is digital premises liabilities are real. They need to be mitigated. And the way to do that is to address simple things like compliance, governance. Those are big words. But when you start looking at entropy, simple thing like passwords, looking at other forms of mitigation to your business that only you know better than anyone else, to look at your P&L and say, hey, what's really at risk? I've got to protect my employees now because I'm putting them on, I'm just arbitrarily saying scott.com. But when that information exfiltrates on that facility due to your DNS problems, which you may or may not know it is, your issues that you've intersected with the cloud, which is nothing but a sieve right now, you selected those digital premises. You put your clients at risk for the failures of, and I'm moving to the third parties now, of those third parties. The auditing of those third parties of the digital premises are going to be mandated fairly quickly. It's starting to happen already, but it should have happened a long time ago because that's what duty of care is. What we've noted over this past several years is this knowing to know liability. Nobody wants to hear about it. Nobody wants to talk about it. Therefore, I'm not liable. But there's a social side to this. We are actually putting together a form of civil defense through insurance that you are going to understand very, very quickly that you won't be able to gain insurance without some form of cyber hygiene. And I'm not just talking about business recovery. It's putting a report in stating that you have really looked at it. Everybody's bad, by the way, and the insurance industry, by the way, is no better than you are. So it's an embracement of the risk that has to begin to happen. Digital premises liability moves into third party, and that's where it gets really severe. We have billion-dollar cases we're looking at right now. We have mapped and we showed Lloyd's of London what we call the PML, the possible maximum loss. That possible maximum loss is actually how your rates are set. We look at the portfolio risk across an entire enterprise, or just basically a D&B look back on these things, where we look at the D&B classes, whether it be law firms, insurance agents, engineering firms, real estate agents, staying in the professional lane to keep it simple for everybody on this feed. But the funny thing is, even the regulators themselves don't have good cyber hygiene. Those who are finding you, we are finding their credentials on the web because of their hygiene is now compromising their ability to do this. Certainly their qualified immunity could be in jeopardy, because this is something that has to be addressed by our industry, the insurance industry. You can't buy a car and operate a car without three things. You need fuel, you need a driver, and you need insurance. Insurance is the DNA of every business transaction around the globe. And then outside the globe, we insure satellites too. So we are in a position right now to be looking at what is our digital premises liability. The lawyers on this feed who have stepped into this world heavily and are devouring this whole effectively new concept of law, where you're starting to matriculate information at a whole nother light. I wrote an article on LinkedIn the other day about data. It's been the legacy issue, certainly for us in underwriting. That old data it's kind of dated. It's not as good as new data. It's not green, we call it. Well, not anymore. That's not the case. We made a contention that data has mass because the aggregation of data and the exfiltration of data at literally a sovereignty level is happening before your eyes. If the vector of how to hack comes from what we call the 0-day patient, much like an actual virus, a biological virus, you could be very culpable here. So the professionals that we're harping on about right now also have the greatest supply chain to basically disseminate this information. You be the, wait a minute, guys. If you start mitigating your own risk, all of a sudden you start to look at your clients. You start to disclose to your clients. The truth does actually set you free in this situation. You start to tell your clients that, wait a minute, we're not that good. This is what we've got. And by the way, we lawyers, we brokers, we accountants need to find a way to disseminate this information. Hey, we're not that good, but neither are you. We're the ones who are supposed to be advising you at a professional level, saying, you better tighten your stuff up or all these things can happen to you. For the attorneys out there, it's particularly difficult for you because there was no policies that got rid of this rotten ambiguity. Is it professional liability or is it cyber liability? One of the things that we were successful at when we went to London, not only teaching them the sheer vast risk that our insurance company carrier friends are already on, was the fact that the two parties, cyber and professional, aren't talking to each other. Well, we got them talking. My dear friend Rogan Dwyer, who I hope is on this feed, spent many trips, many months talking to his brethren at Lloyd's and got them together to discuss this. And we created a product called the Cyber Law Plus. The Cyber Law Plus can extrapolate into the accounting plus, the real estate plus, because the logic is all the same. The risk that we're seeing just on the fine exposure, I don't know if any of you are aware, if you're doing business in Europe here from the US, because most of us do, international, 4% of your global revenue is at risk. 4%. When we mapped what we called the PML just for fine exposures and showed that to Lloyd's of London on the top 20 law firms, which we took the time to do the work with our friends at Breachaware, the fine exposure for one annum, 1 year, was $1.5 billion. We saw cases where people had stuff open for decades. We also are advocating a level of amnesty with our friends at the European Risk Policy Institute. Ivan Savov, I hope you're on this line. What has to happen is stopping this plausible deniability activity. You should be embracing the knowing to know, advising your clients, hey, this happened to me, advising your insurance company, hey, this is happening to me, you're on this. How do we, both the carrier and the business enterprise, start to solve for this problem that are much more palatable in insurance company? Everybody's complaining about cyber insurance and cyber costs. What have you really done about it other than complain? We're seeing a lot of indexes come out of it. Those are good, but they're good till they're not, because the problem with indexes is indexes basically doesn't get everything. Again, data has mass. You don't have the right thing on the index, you still have a cyber loss. That index isn't pretty good. So what we've done is admitted that pretty much everybody's terrible. Start there. Everybody knows it. You might as well just admit it. And then move to what we call ad hoc or partial cyber, the cyber hygienics. The only thing you can do, excuse me, the only thing you can do is move to cyber maturity for a point in time, because your risks are changing markedly over time in both directions. And I say that because some of the new stuff that's coming out, that's one direction, and the old stuff that was already here. The cyber hackers are actually taking old hacks and reinventing them and applying them. They're going into old systems, legacy systems, which are completely unprotected, because that was before the time even the concept of cyber infiltration, exfiltration was even there, but people went ahead and connected these things. The third party risk that's starting to happen, which is a particular note and particularly scary, is the operational technology world. Those are things that go kinetic. They go boom. I'll give you an example of what that could be, and that was 1984, Bhopal, India. We have lots of friends who are on that continent, and we've talked about this. It is so simple to cause a operational technology event, because a lot of the engineering was used to be done with a simple pencil, the old tap of the pencil on the meter or on the gauge. Now everything's hyper connected, and that's all done for accounting reasons, because the bean counters want to know how much productivity we're getting at, how much X amount of widget we have to buy to make the next batch. That's all well and good, but nobody ever mapped the risk. Well, that's not happening anymore. We are mapping the risk. The insurance industry is learning how to do this. And that mapping of that risk is going to be critical, absolutely critical. We have good friends of ours, hopefully they're on the call too, at Velta Technology. We talked about that mapping of the risk, because you cannot understand what it means to be inside of a facility. And this happened to me in Kansas. When you walk outside of a mile-long manufacturing facility and you hear a boom that actually hits your eardrums, and the magic words are going to come out of your mouth, what was that? The gentleman I was with at the time was operational technology. He understood what a SCADA device was. He understood his digital premises on site. That gave great comfort. That's the guy you'd want on the stand when something happened. Because you know what he said that day? I know what that was. Those little magic words were unbelievably comforting, because it had been an IT person who didn't understand operational technology and said the following words, what was that? I was headed out the nearest door. The fact that information is not linear, because in a digital premises of a manufacturing facility has to have people in it that understand the language. You cannot understand how pervasive IT people, totally different language, very capable people, don't understand operational technologies. We as professionals need to advise these people to come up with the concept or the idea of a Rosetta Stone, so that these people are ultimately speaking the same language when it comes to cyber risk. The hackers already know this stuff. They've been light years ahead of us. Our industry is culpable in a lot of this, because we've been paying the ransoms. We've been funding these losses with absolutely no chance of recovery. We have not been taking and aggregating the information on these issues and putting them in a repository to start to break them down. The irony of all those digital premises liabilities aggregated would have allowed for codification of that. We do that for the last 300 years. Our industry is finally coming around, and we do need the help of every single one of you to understand your risks have changed. When you talk to your client, inevitably, especially you lawyers, you're going to be, what do I say to the general public? What do I fill out on this form? You know what you do? Is tell the truth. So yeah, we had a hack, because that little piece of information can get aggregated and can actually be put into a facility where we can start to do the analytics. You know, going from what was that to I know what that was is the game. I don't care if it's in a professional, manufacturing, fiduciary, real estate investment trust. We're all in this digital premises liability together, but we have to map these things. These issues are not going away, and they're literally becoming digital love canals, and all of us are dumping those barrels into that metaphorical canal. But I do know the laws that are on the books are there. The Aaron Brockoviches are coming, and some of these cases are going to be nuclear. It's already happening. Us professionals have an extreme responsibility to our clients because we have access to their critical information. We know to say, hey, wait a minute. I saw this happen in a very similar business, and you should be looking at this. You need to elevate your duty of care. The accountants can actually work with them that these mitigation strategies probably are headed for tax deductibility. Let's give these people a purpose to do the job, to actually get a sense of civil defense on Main Street, and let our militaries worry about our borders. That's their job. But we also have a responsibility to manage our digital premises liabilities, first and third party risk, manage it for not only cyber insurance, but understand the ubiquity of all these risks is going to affect everything else. And one thing I do know is that the common law is already on the books. We're talking about filing stuff. There was an executive order that came out this morning about privacy issues straight from the White House, but they did not handle the dangling participle. And the fact is, the data equity comes with liabilities. When you're protecting things, you're protecting your stuff. It's always great to talk about your stuff, and I'll use the term, and it was kind of quite comical because George Carlin has had many things, and I'm going to use exactly what he said. He called it your stuff and someone else's shit. Well, it's not someone else's shit anymore. It's your stuff because you have control of it. You have bailment liabilities once you seize it. Once you put it into the cloud, you pick that cloud provider. And you see in the news every day, everybody's questioning the placement of the cloud. You lawyers have got to understand that some of the forms, terms, and conditions you did in your contracts do not contemplate. Sorry, somebody had to jump. Said they do not contemplate these contractual liabilities in the very contracts you're putting. Your hold harmlesses that you're putting out, your waivers of subrogation are not even touching these problems. And for those of you who are actually in the IT world on this call, and you have all kinds of statements of work, you have all kinds of master service agreements, pretty much every single one of them I've ever read is all IT focused, not one thing about OT. Ask how that played out with our friends in the casinos in Las Vegas this year. That didn't go too well. Those were operational technology liabilities. They were playing with the shades in the rooms. You don't need ghosts anymore. You can have cyber hackers scare the hell out of you just by moving something that you know is connected. These digital premises are real. These digital premises are full of liabilities. They're full of profit too. And that has been the main motivator for the connectivity. But if you do not map these risks, these digital premises, and understand these things, and us professionals, and say, hey, wait a minute, this stuff can come back to bite you. What have you done contractually? Hey, banks, if you're on the line, let me tell you what you got. If you got a hacked car, it's devalued. If you got a hacked portfolio of cars, you got a problem. Welcome to becoming Silicon Bank through cyber events. These contractual risks are part of our genome. We cover this stuff under general liability. It's called Section 2. For those of you insurance people out there, take a look for the form and show me where those exclusions lie. I know how to fix them. We've talked about it. Our lawyer friends that we are talking to are going to use those fixes, which are possible and known. They're going to come back as a plaintiff attorney, and they're going to say, hey, wait a minute. This stuff has been around for years. Why didn't you do that? Summary judgments are coming, and they're going to come quickly because some of the hygiene problems actually reside in the very courtrooms you're coming. You're seeing entire court systems getting hit. Evidentiary liability, everybody. Digital evidence is alterable, and that's not admissible. And we are gravely concerned about those two. So if we look at the entire digital premises, and it's a genome, you got OT and IT. It looks like a double helix. But you have got to understand there are people and there are friends on this very thing that our friend Edward Millington has assembled. And the irony, it's in the Caribbean. This stuff has not been in the Five Eyes. It hasn't happened in the European countries. But there are people that are starting to understand this. And it's very serious. The walls of Congress, the walls of parliaments around the world don't get this yet. But once this stuff hits the court systems, and once these nuclear, and they will be nuclear, settlements happen, those of you who are in charge, the CEOs, or I call the pre-made scapegoats, you better own this thing because your boards of directors' personal assets are at risk. Because I know for one thing, I'm the guy who will probably say you didn't meet the business judgment rule. I have lots of friends who know what that means here in the insurance industry. And your D&O carrier, your last line of defense, has a way out. That means those personal assets, and someone is going to go down. Embracement of risk is the way out. Saying, you know what? This stuff is for real. We have a problem, but we're doing something about it. We're doing the best we can. For those of you who've seen the movie Spinal Tap, there's a scene where there's a speaker, and he was very proud that his speaker went to 11 because it was one better than 10. Well, the digital premises liabilities that are out there, and the sense that people, if I'm compliant, I'm okay. Compliance is not security, everybody. You have to get to 11 in order to mitigate your own risk. It's your digital premises. We have assets, and those assets are people assets, the human capital that we have. And one of the greatest ones you can do is education. And then with contractual, we'll show you how to do that. Our legal friends who are actually on this feed, you can pick up the phone and talk to them right now and say, what's this all about? One thing I do know is you lawyers want to talk to other lawyers. We have responsibilities that is now leaking into our first responders. We're seeing things that are just unbelievable. Our military. So when we start to look at these risks, we also need to go back and protect these risks. A lot of these things are privacy risks. Everybody says there is no more privacy. Well, you've been busy giving it away for the last quarter century. Just to give you a sense, and I'm going to end this, Edward, is the fact that this should not be foreign to any of you, because back in 1997, this guy here was writing Y2K coverage for the insurance industry. That was operational technology coverage, by the way. That coverage was over a quarter century away being sold in anticipation of what everybody says never happened. That's not actually the case. Things did happen because we did write checks for it very successfully. But in the last 25 years, we kind of lost our way. Why didn't we take the advantage of the 25 years and start mapping what effectively was a cyber risk? In this case, it was code. The mapping of that risk allowed us to insure it. It also led to the fact that we kind of named the perils. The perils that are coming are going to be soon to be defined. And the coverages, and our friends here that are on this feed, are busily trying to say, let's try to insure it, but we have to have the engagement of those parties. We need the enlistment of the professionals that, ironically, we pay. We do audits, accountants. We use you lawyers every day. Our business doesn't work without you. But I'm going to tell you, there's a lot of senior statesmen in the insurance industry, especially the young ones that are coming through, because a lot of them are about to retire in the next 5 years, are not going to intersect with professionals that don't have good cyber hygiene. I've told many, many lawyers, The law firm that's going to be retained is the cyber hygienic one. The one who's not can't be hired. Good luck billing somebody with bad cyber hygiene as proved in court. You're going to owe them a lot of money back. Edward, I could go on all day. I'm very passionate about this. This stuff is actually happening. The cases that are actually hitting right now are very real. You and I have talked about some of them ourselves. They're mounting. We're having first and third party risk coming about. I mean, the United Healthcare case that just happened with regard to one of their subsidiaries causing damages to pharmacies all around the globe are causing potential bodily injury to people because of this little thing called time. I don't have time to go get my medication, and I didn't get it. My physical being is at risk because somebody did not protect their cyber hygiene. The contractual liabilities that was done in the law firm out in California just this, recently. And when that became revealed, that breach harmed children. Let me explain what children are. Children are forever. These time value the data, specifically our children, is harming them. Those kids were hurt not once, but twice, possibly more. The ridicule that these things have. Those files should have been sealed. You are running the risk of giving up secrets that you cannot afford to give, and you will be held accountable, all of us in the professional world. And I don't care if it's an engineer, real estate, one of us brokers, because we ask the questions, what do you do? And maybe they tell us something that's important and we insure it, and we have to keep it quiet. I've done it many, many times in my life because us as fiduciaries, all of us have a social responsibility. That's awesome. For those of you that need to know more about digital premises liability, we have a cadre of law firms who have come around. It's headed up by a group in Boston, some of the smartest people you'll ever met, because you know what? They took a left turn. They said, wait a minute, we got a problem here. Let's embrace this. You might want to learn from your own. If you want to hear from your own, and you brokers out there, I am one of your own. I went out and did this myself. I put 10 years of my life to get this data, and the data is not good. It's not good at all. But we are change agents, and we're really, really good ones. And hats off to you, Edward, for putting this together. I don't care if there's 2 people or 25 people on this feed, but I do know this information is not remaining on this webinar for much longer. You cannot go home not knowing what I just told you. It's very real. So we are trying to get everyone to listen, the regulators, the lawyers, the manufacturers, the OEMs. It's been very, very difficult. But I know for a fact that it's people like Carasec Global that took the time to get a smaller nation states relative to the one I reside in here in the United States to start to work together and say, let's own this stuff. They're going to start to understand that for us to do business on anywhere, because there's one for sure thing. These cyber events don't know borders. So if there's any questions or concerns that you have, which I'm sure there will be many, and I'm more than glad to open the chat thing.
Yeah,
we're going to fade this back to you, buddy.
Right. So yes, Jerry, I think it's been very informative, and I think it's something that we all have to be aware of. And we would have brought this up last year, November the 10th, during the anti-money laundering and cybercrime regional hyper conference here that we had. And you already brought up this topic, and it had really piqued a lot of persons' interest. But like, we have a question from one of the attendees. Say, when do you think people on organizations will actually act on changing the way they currently review risk? You have often said it will take 9/11 events. Apologies for the analogy. But in this case, someone big will take the lead, then the market will follow. So, sometimes when you look at these things, November the 10th, we brought this up. We have some legal minds there, compliance officers, and so forth. We turn to the news and you see the big hats on what's the name of it? You have Prudential Beach with the financial institutions. We have there with the different firms, pharmaceutical corporations. We have again the supply chain to these services. They're causing great tremendous risk. But for some way, somehow, including to my conversation I had yesterday with Actel here in the Caribbean, Eastern Caribbean Telecommunication Authority. like gentlemen say, it takes a 9/11 to change something, but eventually we have very short memories. What do you think it would take for the industry, professional service industry, all industries, to wake up to the fact that we are held responsible? We just think of breaches as GDPR as one, or any data protection law that's out there, in America and Europe and etc. We think about compliance fines, but one of the things that we don't hear much about is the fines, or the cases that are brought up by those who have been affected. Yeah, there's persons like us, other organizations, our customers to us, you know, under and I may state this incorrectly, but under like common law, these particular issues, when one think about it, this is one area that we do not consider. We just think about what regulations that we have failed, the fines that could come about it, but we do not hear too many instances in the newspaper, wherever it is, those persons actually opening cases. So what are your thoughts on this?
Well, going back to your 9/11 analogy, everybody, it's not the one that the 9/11, because that's probably going to be a nation state event, or it's certainly going to be blamed that way. There's precedence for that. Blame the Russians. It's going to be your 9/11. It's already happening. And when you have your 9/11 and goes, and it's a great case because we have that happened 9/11. The 9/11 was actually very similar. Was it cyber or was it professional? Well, at that date, when the case came to bear in the insurance world, was it one event or was it two? They spent years in court just debating that issue. Well, here's what I do know, everybody on this feed. When you've had an event and you've got to litigate it, it all comes down to cash flow. My dear friend Rogan Dwyer has said this: a cyber event is nothing but a cash flow event. And when your cyber 9/11 happens, what's going to happen of note that's going to happen? It's going to affect, and unfortunately, I'm very concerned about this, and I've talked to many OT professionals, is when an IT event, that leakage of something gives someone else the knowledge to do something much more insidious. The Bhopal event always comes to mind. 16,000 people died, 500,000 people injured. But what's really scary, is that concurrent causality of that little leak. It doesn't have to be a big firm. It doesn't have to be a big OEM. It has to be part of the supply chain, which requires that level of civil defense to be looking over everybody else's shoulder. You have to understand what's developed here on LinkedIn has become a community of people, and they're amazing people. To take the time and get on these feeds like your group, Edward, is just amazing, because you have been a voice all over the globe. Because cyber does not know any borders. These events can happen. I mean, you look at the recent Mondelez and Merck claim. That's $1.3 billion in the insurance companies invoked a war exclusion. Insurance companies can sign off on wars. Last I took, it was two sovereigns went head to head and caused a problem because they had a problem with each other. We have really serious problems, but the embracement of the risk has to start happening. I want the lawyers to stop saying, "Okay, we know of known risks." Well, that's complete BS. We all know it time and again. If you see it on the feeds, we know of known risk, and about 3 weeks later, 400,000 people have been injured. I might get cases right here, my own, where I have a MRI facility for my own personal information has gone out. But we also got to stop doing is expecting that, you go out and say, "Hey, I'm going to mitigate my loss, my boo-boo that I caused to you." Had you punched me in the street, that would be assault. Well, this is a digital punch you're doing, and you're going to solve it with credit checks? Well, I've got 92 other credit checks from the other 92 things. I don't need yours. So what you really need to do, everyone that's on this feed, is take care of your own risk. But when you are breached, take the time to reserve your rights. All of you plaintiff lawyers, stand up and listen. Everybody has these rights. It's common law. When you go into my digital car, my digital home, and you break in, and you cause the break-in because you left the key, that's a warranty, by the way. If you're supposed to lock it, and you didn't take care of the warrant and the bailment, if you did, sorry, you're at fault. That's common law. Unless you've otherwise disclosed it on a prior act, a statement of work, and all you lawyers and brokers had better understand this. Before you get to work with these people in this new digital privacy fraught world that we're in, you better look at your letter of engagement in a whole new light. So to answer your 9/11 question, your 9/11 at scale can happen. It can happen, but it's the little 9/11s. Those 30, 40,000 people in an engineering firm that takes a schematic, happened last week, by the way, of some very critical thing that they learn how to do something very bad. So when you look at your digital premises, the concurrent causalities or the ensuing landslide, and unfortunately that landslide's coming, because one thing I do know, and I've seen it time and again, every time a claim bell rings, a whistleblower gets his wings. You can't hide anymore. What's the point? Disclose what you know. Let us codify this. Let us get the analytics. We're talking to the European Risk Policy Institute to do just that because the insurance companies didn't do it. If we put the repository together, we can develop an early warning system. One of the truisms that's out there, a lot of these hacks have a commonality. They're perils, just like wind, weight of ice and snow, theft, fire, which we insure for hundreds of years with great outcomes. Why haven't we done this with cyber, IT, and OT infiltrations and exfiltrations? The thing is, we're starting to learn in our enforcement, our capabilities. The insurance industry is the ultimate regulator. You can't buy your car without insurance, and it's coming. It's already happening. I have insurance company up in Maine. They're not insuring Kias at all. They're saying, you know what? Too much risk. They're walking away. And if you don't think that's going to happen at scale shortly until you tighten up your stuff and you can prove it otherwise, for those of you in who have a supply chain and are not getting this message of your DPL, your digital premises liability out to your clients after today, you have a knowing to know liability. Go ahead and don't see what happens. But complicity starts to come into the game, and I'm very worried about people who just get caught in the old lackadaisical 20th century way of doing things. We're a quarter century into this problem since Y2K. It's a date stamp. It actually happened. What the heck happened? I say to many of our people on this feed is like, I think we had a traumatic brain injury in the insurance industry between, the December 31st, 1999 and today. This stuff actually happened. We knew what we're doing. We did it, but we kind of dropped the ball. Paying people to fund ransoms has had an awful effect, which is basically we have funded this stuff, and that's got to stop. So getting these people down to a monetary level, but the problem is now you've taught them to leverage things that are so scary, and you've taught them to go deeper and deeper to the point where ransomware is actually a service. You can go out to the web and get hired. Our regulators need to step into the breach too, my friend. They don't understand this stuff. They just don't. We see all these edicts coming out, and the irony of that, some of these edicts are already being contemplated through common law reapplied. And that's what the insurance industry is waking up to. We're reapplying the common law. We're going to use it. We're going to use rights of recovery. We're going to use reservation of rights. These are accounting functions because when you reserve your rights at scale, these are liabilities that need to be put on your 8K, your 10K, your risk disclosure statement. It's not being done. Sorry, SEC, we love you for that, but you're not doing your job either. You already have rules on the books that could be applied. GDPR can charge you 4% of your gross revenue, global revenue, for you to even do this. They need to step up and start finding these people. The mapping of the risk is very real. It's real dollars. So the case law that's coming is going to be awesome to watch. We're talking Tom Clancy stuff. We're talking Asimov. We're talking all rolled into one for that movie that's inevitably coming. Netflix, you got to pay attention. The good movie hasn't been made yet. It's about to happen, and it's going to be a thriller.
I think
So
the
9/11
movie is going to be a light movie.
I'm living it.
You're living it. We're living it every single
But
day.
what we're happening is that what the courtesy of some of the most wonderful people in my industry, and I'm teaching them insurance. And let me explain what we mean by that, Edward. Insurance, everybody thinks it's policy, words on a page. It's not. It's my friend Matt Wainwright, who runs our insurance as a service component, understands that the transference of risk, which is what insurance is, can be applied to all these people who run managed services like Andrew Alston, Andy Jenkinson. We've got Julie O'Toole. These wonderful people run these wonderful companies that can actually elevate your duty of care, transfer that risk to their concepts, their ideas. It's a form of insurance. That's the embracement. Hey, look, I got a problem. How do I fix it? You can take that to court. Any defense attorney who should be telling their clients, say, listen, retain me because I understand digital premises liability. I got to tell you, I don't mind that retainer. Beats a divorce. But I'll tell you what, you want to mess with your P&L right now, start getting reservation and rights at scale. I'm looking at one. I'm going to leave the name of the entity at risk. If they had got the hundreds of thousands of reservations of rights, it's a function of generally accepted accounting principles. Those are reserves. Those are liabilities that need to go on the books. Banks, publicly traded companies, your valuations are at risk. I've got friends in Wall Street that call me every day at Morgan Stanley, TD Bank, every day. They know that this is looming. All of a sudden, the movie The Big Short starts to come into play because the reality of this thing is marked bombs out there are going to happen. They're going to be in your stockholder meetings and holding up the 8K and the 10K. Where was that in your risk disclosure statement? And by the way, you attorneys better be advising your publicly traded companies to get that stuff in there, because when it goes down, it's not in there. Now we're up in a whole nother can of worms called criminalities. Material omissions are fraud, everybody. So we need to get ahead of this. We need to get this and stop placating your stockholders and start admitting to it. Because I'm going to tell you, your stock valuation's been done. Equifax got hit and they took a very strong posture. They actually came out with their own form. Mark Bagor and Jamil Franchi, who's their CISO, actually took and filled out an entire form, the state of their cyber. I was so blown away by that. Jamil sent it to me, almost like a heat map. It was pretty awesome to see a very large company who's deeply involved in data actually take and say, listen, we weren't that good. This is what we're trying to do, but we aren't perfect. Everybody knows that's called human. And you rating agencies out there, you better start paying attention, because that scene from The Big Short where the woman had the glasses and she's sitting there, you're not doing your jobs. Your heat maps are not hot enough, not even close. We're mapping this stuff and it's not pretty. And it all starts with admitting that you're not that good. Move to cyber maturity. Start defining what cyber maturity is for your business. And for us professionals out there, you need to help our clients define what their cyber maturity is, because it's on you. And the second you do, your likelihood of getting sued for errors and omissions claim starts to vaporize. You've got to embrace it. You got to own it. And trust me, you want to be a trusted advisor, that's how you do it in the 21st century. Edward, I could go
Yeah,
on all
Gerry.
day about this. I'm super passionate
Yeah,
about
I
it. You
think
can
we're
ask
gonna
all the
cut it
questions
short. We
you
have
want.
more than
I
enough
have
time.
mapped this stuff till I'm blue in the face.
Yeah, I think we cite quite a bit, and I think is a level of understanding that we have to really work on the cybersecurity maturity, or the information security, or security maturity, or however business want to look at it, in building that. And until that level of awareness is really highlighted within organizations, we will be forever here, continue to preach and advocate in this particular area. I have one question. I think it was shared with us, our statement, but this whole thing can take years with time to take it to the court, then the court process, the requirements to get litigation, investment to process the court case, and this is something that we would have discussed here within the region itself. It takes so long sometimes to have a case drawn up, and I'm not quite sure for over where you are, that can be very costly for us. And I think this is really one of the reasons why many entities might not, care too much. Many weeks ago, I had the Caribbean Broadcasting Corporation here, which is the local TV station. The person asked me, what recourse does we as the customer have? I said, well, we have to take the organization to court. That's the only option we have. But when you look at the whole process itself, it can take a very, very, very long time. So I think it's something that we need to understand here. I don't know if many businesses are banking on this area, but I think that as time goes on, I think these barriers, unless everything is very coolish, working together to still continue to frustrate the environment. But I think that like any other place here in the Caribbean, America, even Europe, whoever starts setting the precedents, we all start to follow. So I expect to see that as we see more supply chain risks occur, as we see substantial breaches, as we continue to see identity loss and fraud and so forth, I think it's going to be a cry, from the general public. We need to do something. And when that happens, just like what happens with the GDPR and everybody had to rush to be compliant, you're going to see that. So our task today is to make sure that we draw this awareness to everyone. We have persons like Gerry here continue to advocate. We're here to help persons to map where the data is, to help build your security, advice, etc. So again, I want to thank everyone for being online today. And we are going to share this video as soon as possible. So those who may have missed it or you want to share it with your network, you can go right ahead. So again, thank you very much, Gerry. I greatly appreciate your time.
Absolute
And we
pleasure.
will keep
Thank
in
you for
contact.
the forum.
Okay, take care and all the best.
Thanks, guys.
Okay.